Hi everyone, Hayder Shikara here from Justice Family Lawyers. I'm here to discuss what are the best interests of the child. Now, this is an interesting concept. It comes down to a section in the Family Law Act under Section 60cc. Now, you can look it up yourself. Basically, there are two paramount considerations for the court to consider when they are making a decision about what is the best interests of the child. Now, the first is the benefit of a child to having a meaningful relationship with both parents. And the second consideration is the need to protect the child from psychological or physical harm, or exposing the child or subjecting the child to abuse, neglect, or family violence. Now, out of the two primary considerations, the court does place a greater weight on the protection of the child. So the protection of the child and the needs of the child from ensuring that the child is protected from a psychological and physical point of view is more important than ensuring that the child has a meaningful relationship with both parents. Apart from those two considerations, there is a whole list of other considerations that the court needs to consider when making a decision about what is best for the child. Other points that the court may look at is what the child's views are. Now, this does change based on how old the child is. Obviously, the older the child, the more the court will be inclined to listen to their views. However, it is not required to do as a child wishes, so there is a clear distinction there. Other things that the court needs to consider is the relationship between the child and any of the other relatives or family members, including grandparents, the willingness and ability of each parent to look after the child, and also if there are any other cultural considerations, LGBTI, Aboriginal or Torres Strait Island, or anything else really, which requires the court to consider when making these decisions.